Okay. Go!
Will you hand me my screen box?
Now go.
All right, Mr. Clayton, you're seeking $4,532.83. You say for outstanding rent, outstanding bill, and you all live together in some co-housing arrangement.
We previously,
I'm sorry?
we previously did, Your Honor, not
Right.
current.
Yeah. And obviously it was your case I was referring to about all the oral agreements.
Hmm.
So, and then I did read that the canon said that they believe that they covered their half of the deposit by buying the washer and dryer and, you know, all these informal arrangements. So first of all, let's start off, Mr. Clayton, was there any formal agreement between the parties? Anything reduced to writing?
There was not, Your Honor.
Okay, and tell me why you think the canons owe you money.
Thank you, Your Honor. On December 17th of 2023, my partner and I entered into a lease agreement with the defendants at 2403 79th Avenue. Subsequently agreeing to sign this lease, a verbal agreement was made that I would pay for the security deposit in full and the pet deposit in full, and the defendants would purchase a washer and dryer in lieu of their half of the security deposit. On September 9th, 2024, an altercation occurred between one of the defendants and a minor. After several attempts to mitigate the altercation from myself and partner, I determined that the living residence was no longer safe for the minor, myself, and my partner. I then took steps to sign a new lease and a new residence on September 26th, 2024.
Okay, so hold there. So let me make some notes.
Sure.
Okay, so you're the one who signed a lease with the owner of the property. The canons did not sign the lease. Is that accurate?
That's incorrect, Your Honor. They also signed in the lease as well.
Okay, so you were all co-tenants
That's correct, Your Honor.
at the property, but neither party is the owner of the property.
That is correct, Your Honor.
And the lease is for how long?
It is for 1 year.
Starting what day?
December 17th of 2023, Your Honor.
Okay, so it was December through December.
Correct.
Okay.
It was through November, Your Honor.
Okay, right, through the end of November.
Yes.
And Mr. Clayton, you determined that you couldn't live in that joint arrangement based on the concerns for, is it your child?
Negative, Your Honor. The
Okay,
child is my partner's.
Okay, your partner's child, and you left when?
On October 1st of 2023, or excuse me, 2024.
October 31st?
October 1st.
First, okay. Okay, so this is a 2-month break on the lease. Did the owner require the parties to pay it? Were you expecting the canons to assume the balance of the lease? What were your
When this occurred, I had agreed because I was still wanting to honor the lease agreement on my end. I had agreed to pay for the rent for the month of October until the lease was ending because it was going to end in November.
Right. Okay. So the amount you're seeking for rent, tell me about that. What's that?
So after vacating the residence, 2403 79th Avenue on October 1st, I still tried to, me and my partner still tried to honor the verbal agreement and use the washer and dryer at the residence. But continued animosity from the defendants, in particular Craig, towards my partner, made her too uncomfortable, and then she purchased a washer and dryer. So when she purchased that, I felt that voided the verbal agreement, considering that I no longer required the services of the washer and dryer at 2403 79th Avenue.
Okay, hold on a second here.
No worries.
So you and your partner the Canon stayed in the property after you left. You and your partner were coming back to the property to use the washer and dryer based on your understanding that it, in a sense, was some communal property because it was used as a version of the deposit.
That is correct, Your Honor.
Okay. And how long did you use that before you stopped using it?
The last week of September was the last time that the washer and dryer was used at 240 379th Avenue.
Okay, so you moved out on the 1st of October.
That is correct, Your Honor.
So it's not a situation where you then wanted to come back to the unit to just use washer and dryer. You're saying
that is what they intended. What was attempted to be done, Your Honor, by my partner.
Okay. And you weren't allowed in, or what's the story? You just chose not to come back in?
She just simply felt too uncomfortable and then purchased a washer and dryer.
Okay, so what you're saying is that because you had to forego 2 months of access to the washer and dryer, that negated the agreement on the deposit.
That is correct, Your Honor.
Okay. And so I'm assuming what you're telling me is that in your theory on this, because the washer and dryer in your mind no longer is half the deposit, they owe you half the deposit. Is that?
That is correct, Your Honor. Well, the way that I am phrasing it or framing it is this: because we no longer require the services, the last month of rent they should be responsible for, because the washer and dryer is no longer a part of the verbal agreement. I no longer require the services.
Right. Okay. So, okay. Are the Cannons still in the property? Cannons?
No,
We are not.
no, we're not. We moved out.
Okay. Did the landlord ever take action against? Was the rent fully paid through the end of the lease?
They did not pay their half of the rent in November. It was eventually taken out of the security deposit with a $50 late fee. We paid our half directly to Green Property,
Our portion.
our portion.
Yes.
Okay. So the Cannons paid through the end of the lease. Mr. Clayton, you did not pay the month of November. Is that accurate?
That is accurate.
Okay. All right. So the landlord then took the other half of November rent out of the security deposit plus a late fee assessment. And
the late fee was waived, Your Honor.
Okay. Took the other half of November rent out of the security deposit. So what exactly are you asking for, Mr. Clayton? Make that clear for me if you can.
So what I am asking for is, after the voiding the verbal agreement, the last month of rent and full property in full for the property 240 379th Avenue, and the water bill and the repair of the pet damage as I requested. Those are the things that I'm asking for.
Okay, so give me amounts associated with each thing.
Okay, so the last month in rent is $1,795. The water bill that I requested for them to pay was $129.50, and then the pet damage in total amounts to $379.76.
$379.76.
That is correct, Your Honor.
Okay, and that's what the landlord assessed as a result of
The damage
that
caused
the
by
landlord kept in the security deposit.
that is correct.
And you believe that the Cannons were responsible for the pet damage because they had the pet, I'm assuming, is what you're going to tell me.
Yes, I don't have a pet, Your Honor.
And pet was a dog, a cat, what was it?
Pet was a cat.
And tell me about the water bill. That's a monthly water bill. That's a 6-month water bill.
It's a monthly water bill, Your Honor. Basically, after I vacated the residence, I requested to Kinsey Cannon that Since we are no longer occupying the residence, the water billing cycle that is applicable to 2403 79th Avenue should be paid by them, seeing as they're in the residence and still continue occupying.
Okay, so in your mind, the 129.50 was a water bill for the month of November where you weren't there, and since they were the sole occupants, they should be responsible for that bill?
That is correct, Your Honor.
And then the rent is your half of the November rent,
That is correct, Your Honor.
which was retained by the landlord as part of the deposit.
That is correct, Your Honor.
That wasn't returned. Yeah. Okay. And your theory on that is they owe you November rent because,
Due to voiding the washer and dryer verbal agreement.
and by voiding the agreement, what you're saying is that the relationship between Mr. Cannon and your partner became untenable, and two of you chose to leave, which meant you couldn't access the washer and dryer because your partner wasn't comfortable doing that.
That is correct, Your Honor.
I'm assuming, since I haven't heard it, that there wasn't a negotiated discussion about this. There wasn't, okay, we're leaving because of this has become a difficult place for all of us to live in. So we're leaving as of the 1st of October, and you guys are promising to pay the rent and the water bills. Was that ever discussed? Was that was
there were discussions in regards to some of that stuff. Obviously, my request of the water bill and my request about the pet damage and stuff like that. But in my mind, when we moved out, and in my partner's mind, it was okay. We've moved out, but we still, according to the verbal agreement, have access to a washer and dryer. So we should in theory still be able to use.
Okay. And now give me your theory as to why they should pay for your November rent. You asked for the half of November rent that was held by the landlord. So why are the Cannons responsible for that?
I feel that the Cannons are responsible for that because of the voiding of the verbal agreement about the washer and dryer. And since that was voided, they should be responsible for the full amount of rent, since that we, one, no longer occupying the residence, and two.
Okay. When you all made the initial agreement that you would pay in cash the security deposit and pet deposit, the half of it, and you agreed that the Cannons could pay their half because they were short funds apparently at the time, could do it by purchasing a washer and dryer. So when you made that oral agreement with them, and here's why oral agreements are really difficult, I'm going to assume that you didn't put in contingencies, which are, if this agreement is not adhered to, then this happens. If we have to vacate, then this happens.
There were no contingencies, Your Honor.
Yeah. Okay. I guess the way I would say it is your belief is that that's the equitable thing to have happen here. That is correct. Because you felt obligated to leave because of the relationship had deteriorated, that even though there's no contractual understanding, you believe that that's the right or fair thing to have happen.
That is correct, Your Honor.
Okay. All right. Cannons, go ahead. Either one of you, and let's have just one of you do the talking so we're not going back and forth.
Okay, I will try. Your Honor, we believe that Evan and Jade made an agreement, a verbal agreement with us when we all moved in, that half the security deposit was ours. We believe that half of the security deposit would more than cover any outstanding bills, any extra that was added onto the pet deposit, which we did definitely pay a $300 pet deposit specifically for our pet. That's why we paid more when we moved in. We believe that Evan and Jade moved out of their own accord. We are not responsible for the costs associated with them moving or any costs that they accrued because of that. The washer and dryer was always available to them. They did not feel comfortable. It was not a comfortable situation, but we did not stop them from using it. We never asked them not to use it. I was never hostile towards her when she was using it. We're not sure how else to proceed as far as making it clear that we don't owe more. And in fact, we believe that Evan, after moving out, took our half of the deposit and is now trying to sue us for that money again. And so I guess that's kind of where we stand right now, Your Honor.
Okay. And what do you mean he took your half of the deposit?
Well, we should have had half of the deposit coming back to us, and we have gotten no money back, and they used it instead to pay their rent and for the other bills.
Okay. So neither party received anything from the landlord by way of a return on deposit?
We did not.
Okay. Mr. Clayton, did you receive anything from the landlord on return on deposit?
I did, Your Honor. I received $296.09.
You said $209.96?
$296.09.
Okay, thank you. All right, and to the canons, Mr. Clayton had indicated that there was a water bill of $129.50, which was essentially the water bill for November when he and Jade were no longer residing there. Jade is correct. Did I hear that right?
Yes.
Mr. Clayton?
Correct, Your Honor.
Okay. When Mr. Clayton and his partner were no longer residing there, there was a water bill of $129.50. And the assumption, I think, is that that was retained by the landlord to cover the water bill and not returned in the deposit. And Mr. Clayton believes that since he obviously wasn't there to use any of the water, that the canons are responsible for that bill. Canon's thought on that?
We attempted to pay the bill. It had already been paid by the landlord company. When we saw the charge on the bill, we assumed that our half of the security deposit that Evan took would cover that. We have offered in mediation 2 times to cover that one bill because we did want to cover that one bill. But now that we've gone through all of this, we do feel like our security deposit should have covered it.
And Mr. Cannon, you said that besides purchasing the washer and dryer, you actually paid $300 toward a pet deposit?
No, Your Honor. We bought the washer and dryer, and then we paid $150 extra in rent for our first month to bring it up to $1,651 that we paid for the total deposit. Half of the security deposit was our rent, which was $2,850 plus a $300 pet deposit. So we paid the pet deposit ourselves and also half of the security deposit.
And Mr. Clayton, you paid the deposit, the full deposit, or half the deposit in cash. Is that right?
No, Your Honor. I
Tell me how
paid
that went.
the deposit in full,
Okay.
the full amount.
And
There was
both
the reason why
the regular deposit and the pet deposit.
that is correct, Your Honor. The washer and dryer was purchased because there was no washer and dryer in the residence when we moved in.
Right. And what did you pay in total between the deposit? What was the deposit?
$3,095.
3,000, how many?
$3,095, Your Honor.
95. Okay. Thank you. And what was the pet deposit was? 300?
$300, Your Honor.
Okay. So you paid $3,395 to the landlord.
That is
No,
correct,
Your
Your
Honor.
Honor.
No, Your Honor. The $3,095 is including the $300.
Okay. So we have a little dispute here. Is the pet deposit part of the $3,095 or not part, Mr. Clayton? Was it separate or not?
It is separate, Your Honor.
Okay. So you paid $3,395.
That is
Okay.
correct, Your Honor.
And canons agree you were the pet owner?
Yes, we do.
Yes, we do.
Okay. And besides paying the pet deposit, the landlord then chose to retain an additional amount, according to Mr. Clayton's figures, $379.76 of additional damage in retaining deposit to cover that damage because of, I don't know, urine on the floor or scratch marks or whatever
It
they
was
were
because
claiming the cat did.
it was because of scratch marks, and it was so what we assumed was it was the $300 pet deposit that they retained, and then they added on $79, apparently for 4 light bulbs and also for some repairs. The light bulbs having nothing to do with the pet deposit.
Okay.
Honor, according to the disposition form, the description is tenant charge, replace garage entry door, weather strip, 3 light bulbs, and painted over dog scratches on interior garage entry door. Replacement tenant charge, part supplies, replacement weather stripping for garbage for garage access door, and replacement light bulbs. That's the way it's described on the disposition form.
For the 379.76.
It's kind of divvied out. It's for one charge for the replaced garage entry door and weather strip, it's $320. For the parts and supplies replacement weather strip for garage access door and replacement light bulb is $9.76, and paint for garage door pet damage is $50. So if you total those charges up, they equal $379.76.
And it's your understanding in looking at that, and I don't think that I saw that in any of the exhibits that were filed in this case. It's your understanding that those other damages were damages the landlord was seeking as a result of pet damage.
That is correct, Your Honor.
Okay, so the canons are saying, how did the pet damage a light bulb?
That is.
It's just more so how it's described in the
right. Yeah. No, I understand that. I'm not asking you to validate what the landlord is asking for. They're raising an interesting question. If that's what the landlord is retaining money for, it then raises the question about how much is actual damage caused by the cat and how much is something else. But okay. And for the canons, Mr. Clayton's explained why they left at the beginning of October. What's your view as to that?
Our view is that I had been living off and on with Jade. Jade is my daughter, who is Evan's partner. Jade had lived with us for the last 5 years at various points of time. Her child, Aiden, had been with me most of the time, often left alone with me to babysit. We would pick them up from school when Jade was in college, or if she ever had anything else to do. So we were very involved with their life. When we moved in, that was why we moved in, is because we were also involved in each other's life. Since Jade had gone through a divorce, I had taken on a role of disciplining Aiden, who had exhibited clear discipline problems. That had never been an issue until September, when Jade felt like what I said to their child didn't warrant from their behavior, wasn't warranted from their behavior. I disagreed. But at that time, both Kinsey and I said, we will step back from parenting Aiden at all, because this is not something we wanted to ever do. We would much rather just be grandparents and take that role. At that point, when we backed off, things became more and more strained as we continued to try to live together. Both Jade and Evan became uncommunicative. They couldn't have a conversation with us. We just felt really uncomfortable all around. I think everyone felt uncomfortable, but it was never unsafe. At that point, we were still trying to make it work when they let us know that they had found a place and were moving out.
This sort of played out how I thought it might, which is we're trying to patch together a legal theory as to obligations here. And we don't have documents upon which we can rely. We just have conversation. And I will say that the parties are fairly consistent in what you're saying. I don't doesn't appear to me to be that anybody's fabricating anything. I think it's more a situation in which two things. One, you had somewhat different perspectives on things, like, for example, whose fault it was that the co-housing didn't work out come October. I'm sure you each feel differently about that. But that, I don't think that really plays into this. And that's why I was saying to everybody at the beginning that the law doesn't ask me to determine who has the moral high ground here, or who was right, who was wrong. The law asked me to apply the law. So the law here is, number one, there's no written contract. So you can have agreements that can be enforced that are not in writing, but there has to be a clear understanding of the parties and a clear basis for the court to find that an agreement existed. The other awkward thing about this case is, for me anyway, is that some of the damages are based on the retention of a deposit by a third party, that is the landlord, who's not present in this proceeding. So there hasn't been a claim against the landlord for retaining the deposit and the amounts that the landlord retained and not returned. So on Mr. Clayton's claim that he should be paid for November rent because the landlord retained that and didn't return that, there's no contractual agreement between Mr. Clayton and the Cannons regarding that. And Mr. Clayton and his partner were not present for the month of November and acknowledged not paying that rent. So I will find that that's not something I can award, even though I understand why Mr. Clayton is asking for it. The law would not allow me to find any theory upon which I could award that. We cannot do equity here. Likewise, on the pet damage, I can't look at what the landlord, the basis for the landlord's retention of a deposit and say that's legitimate or not legitimate. It was retained. If there's an objection to the landlord retaining that, then the proper thing might be to make a claim against the landlord. And maybe you're a little bit ahead where if that claim is denied, then you could say, well, it's the Cannon's fault because their cat caused the damage. But at this point, I don't find a basis for awarding that. The only thing I will do is award Mr. Clayton the amount of the water bill, which sounds like that's what was offered in mediation anyway, which I kind of hinted at. The Cannons agree that Mr. Clayton and his partner were not present in November during the time in which they incurred the cost of the water bill. The landlord retained that part of the deposit. And so I will find the Cannons responsible for the water bill and the filing fee. So total judgment for Mr. Clayton in the amount of $179.50. All right.
Thank you, Your
Honor. That judgment order will be in your file at district court in the civil office. Thank you.
Thank you, Your Honor.
Thank you.
Our $J Group Holdings versus Azar Segdahi Safel. So, what was that?
Ready, Your Honor.
Good afternoon, Your Honor.
And where are we on this?
May I pass to the bailiff to hand this to the,
What is it?
this is the petition for joinder before federal court we filed, Your Honor.
The petition for joinder?
Yes. We amended the complaint and we added R&J Holding to our federal complaint in U.S. court.
No. Have you seen that?
I have not, Your Honor.
Well, you can't just give me things and expect the court to take them without showing opposing counsel.
Okay, I have a copy for him. He refused to accept.
Your Honor, she hasn't tendered it to me. Also, for what it's worth, yesterday at about 11 o'clock in the morning, the defendant served upon my office a ream of pleadings, responses, motions to stay, motions to dismiss, and so on. And I did my best.
For what case? For this
for
one?
this case. We're not a part of that federal case, and she is doing the classic attempting to turn this into a federal case, when in fact, it's just a summary proceedings action, Your Honor.
Absolutely not, sir.
And I did
No, you did
also give her copies of everything I filed by overnight mail and today. I handed it to her a while ago and she gave it back to me. I'm not going to fight over it, but they served me with a series of motions. I had to
I
respond.
don't have any motion.
No.
Yes, Your Honor, the package in front of you has a motion to dismiss, has petition for a stay, has answer to the complaint. and
Okay,
has a
you filed these
counter-complaint.
today? Yeah.
No,
today.
we filed it yesterday, Your Honor. You only gave us a week to answer. Remember, Your Honor?
Your Honor, you gave her.
Oh, ma'am, I remember everything I do. Do not try to address me that way. I will have a memory that will throw you in circles. So don't come at me like that. Because if you come at me like that, you're going to get hurt.
I respect.
Counsel, what were you saying?
Your Honor, I was saying that as I recall, and I wouldn't challenge your memory, you may as well, when we were appeared and she asked for the opportunity to present some reference to this federal case, you
Yes.
said, we're going to adjourn this till next Friday at 3, and you can deliver to me a copy of that federal case so that I can look at it,
Right.
not file a whole host of other pleadings and other matters at the last minute. I mean, that was tough for me to handle, but I got it out, Judge.
Well,
A copy of federal pleadings is part of that package that was hand-delivered to this gentleman and to the court, Your Honor.
We have nothing to do with that federal case, Your Honor, at this point.
Now
She
you
has a
do-
case against Wells Fargo, who was a prior mortgagee in the case. We have nothing to do with it whatsoever. We're the deed holder of the property.
there's also been a parties added.
They counterclaimed against us yesterday at 11 o'clock in the morning and filed several motions. No parties have been added to this case, but she says she wants to add us to that federal case, and I
Well,
encourage.
the caption is changed.
Correct.
Can't just change the caption.
Well, we haven't been served. I got the document.
Counsel, I get it. I'm just saying, this caption that I have on your documents is not the caption of this case.
I'm sorry?
The caption here, who is Carl Stafford?
Carl Stafford is here. He's my.
I don't care if he's here. He wasn't a party to this case, was he?
No.
It says all residents of the house, and he's the resident of the house.
You can't just change the caption.
What do you suggest I do, Your Honor?
You don't want to hear that. I suggest maybe you get an attorney because I just don't.
She is an attorney, Your Honor.
Well, that's even more alarming. I don't even know what to do with this because the caption has changed, right?
Yes.
You served motions and apparently there's a counter complaint that the other side or whoever was supposed to add doesn't have an opportunity to answer. I don't even know if there's been a summons issued for these other parties.
Yes, there has.
Are you an attorney?
I'm not a bar license holder attorney. I went to law school.
Counsel, you filed an amended complaint, correct?
I did, Your Honor.
All right.
We have not received that.
I gave it to her.
No, we have not received,
I
sir.
gave you the packet and you gave it back. to me.
When was that,
Just
sir?
now, I gave it to
You
your
gave
husband.
it to
You
me
two want
now.
to have your own darn conversation. You can do it outside. You don't need me here.
I
I'm not going to be a third wheel on a date in my courtroom.
I'm sorry, Your Honor, very sorry. I did give her all of those pleadings and the amended complaint in a white envelope, which she
Did he-
handed back.
Did he give you an envelope and then you give it back?
Yes, because
Why?
because I tried to give him the joinder and he gave it back.
She never handed it
This is
anything.
like,
to me.
this is like kindergarten. I'm going to accept the first amended complaint, counsel. You can serve it on her in whatever way you wish in terms of either you can do it by email or you can serve it by first class mail. If she won't take it, she won't take it. This, what you filed, which starts out entitled plaintiff's defendant's answer to the counter, you're going to have to refile this. I'm striking this pleading. You can't just change a caption. Well, guess we're done. And so I'll give you a week to get that out. I realize it delays the proceedings, but I don't think I can do anything else because I don't know why these parties are running around in this case that you just added to this as the petition to stay is filed on this is crazy. You're gonna have to start over. I'm striking all of that you
Okay.
filed, and you're gonna have to just do it right. I'll take yours, you serve it, they'll have to answer, and then we'll go from there. I don't know that putting it out to next week is gonna do us any good, so I'm gonna put it out to the 14th.
Thank you, Your Honor. I would ask the court if it may. She hasn't paid rent. They haven't paid rent since November. The rent for November, December, and January is $5,000 a month. And the rent for February and March is $5,500 a month. I would ask that you ask them to escrow.
What is the current monthly amount of rent?
It's, there's a holdover provision, but we'll accept the normal rent, Your Honor.
About 5,000?
5,000 for.
I'm gonna order escrow.
Escrow, we would pay it in escrow, Your Honor, but not to them because they have to sell the property to us.
I'm gonna order that you pay escrow to the court in the amount of $5,000. I'm not gonna do a proration back to the original. You'll start that March 1st. It needs to be paid within 7 days of the date of my order, and then needs to be paid each month while this matter is pending. Do you understand that?
Yes, Your Honor.
Please,
Thank you, Your Honor.
Order to that effect. I will
So
adjourn this.
February rent and March rent.
I can only have March rent.
March.
I could prorate a day February, but I'm
It's
not.
not necessary. We'll accept the,
March 14, 2025 at 1 p.m. I feel a cold coming. 1 p.m.
Your Honor. Have a nice weekend.
Yeah, I will now. All right, now give it. Yeah, give it, because Ann,
Can I take it?
can you what?
Could we submit the joinder or no?
You may, if it is in proper form, submit it anything that you like, but not to me.
Okay,
You can file it with the clerk's office once the file gets up there.
by all means.
Just don't. Just don't. Just
Are we dismissed, Your Honor?
bye. Yes.
Thanks, Judge.
Okay. That's it. You know, it makes me less fearful of any of these cases because it can't be that bad. None of them can get there. What?
I said I'm
You meaning it could get that bad?
You always tell me it's trouble.
Oh, no, you know what? And you're right. I do say that to you. And I am going to take that back after what I just experienced.
Thank
You're nothing.
Are
you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolutely an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in here. You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so
No
let
case.
this
Trust me, at the end of the day, I'm sitting up here, I'm the one that needs a drink.